So I just want to say good evening, everybody. I'm Ave Seltsam. I am the interim executive director at Connected SF and Connected SF Institute. In conjunction with my colleagues who are on this call, Griffin Lee and Ian and Sarah from Connected SF Institute, it is our pleasure to welcome Alexandra Prey for this meet and greet. Ms. Prey will run against Phoebe Maffei for the seat vacated by outgoing Judge Geraldo Sandoval, who is not seeking re-election. She worked in the San Francisco Public Defender's Office and for 10 years was assigned to the trial rotation, gaining extensive courtroom experience and conducting more than 50 jury trials. At present, she reads case law, writes motions, and provides advice to colleagues in the research unit. I give you Alexandra Prey.
Thank you so much. And thank you so much, everyone, for being here. As Ave said, I am Alexandra Prey, and I am running for the Superior Court in the June election. If you've been to other events with judicial candidates, then you already know that we really can't tell you very much about our positions on hot button issues or really any political issues or issues that would come before us. The whole point of being a judge is being neutral and keeping an open mind. So we can really only talk about our past and our experiences and our values and how that would inform us if we were to be elected. And so that's what I'm going to do. I am originally from Rochester, New York, and he's retired now. But when I was growing up, my dad was with the New York State Police. He was a trooper when I was very young, and then he became a sergeant inspector. And in that time, Rochester was very much a company town, and everybody I knew had parents who worked at Kodak. And I was really proud that my dad had a different job where he helped people and he served our community. And that was something I internalized at a very young age. And I always knew that I wanted to have a job where I helped the community as well. Um, as I grew up, I really liked reading and writing and learning. And so when I was getting ready to graduate college, law school seemed like the next natural step on my trajectory. So I decided to go to Northeastern University because they have a focus on public interest law. And when I started law school, I didn't know exactly what kind of lawyer I wanted to be. I did know I wanted to help people. I was interested in civil rights. I did know I did not want to practice criminal law because that was my dad's thing. And I wanted to kind of forge my own path. But then I actually got studying in law school and I found criminal law really interesting and I was good at it. And so for my first internship, I decided I would do a criminal focused internship. And when it came time to decide whether to apply at DA's offices or public defender's offices, the majority of my classmates who are on the criminal track were applying at prosecutors' offices. And that made sense to me because I think naturally, and could be because I come from a law enforcement family, but it did seem to me that naturally prosecutors take the more kind of sympathetic role in working with victims and serving, the people. But somebody has to represent defendants, and I was worried that not enough people were doing that. And so I thought I would try that out and see if it was something I could do. And I worked at a small public defender's office in a neighborhood in Boston. I worked with some really great attorneys, and I really enjoyed my internship. And I realized that criminal defense is something I could do. And I think it may be partially because I've always been someone who's a little more guided by logic and reason, and I'm able to separate my emotions. And so I could read cases and I could feel sympathy for the victims, but still understand my job was to represent my client's interests. And I could also move beyond sympathy for the client and look at, ultimately what is in their best interest in resolving this case. I did other internships in international human rights and housing and benefits. And when I graduated, I decided I had always wanted to live in California. My grandfather, when I was growing up, lived in Portola Valley down the peninsula. And I had been too scared to be so far from home for college or law school. But when I graduated from law school, I decided I was ready. So I took the California bar and moved to the Bay Area. And it was 2008, and it was a terrible time to be a new graduate with no experience looking for a job. So it did take me a while to find a job. But while I was looking, I volunteered at the Tenderloin Housing Clinic, and I assisted attorneys who were representing clients in unlawful detainers. In early 2010, I got a job with the San Francisco Department of Elections as a poll worker trainer. And in that job, I helped devise a curriculum so that all the poll workers were familiar with election law and to make sure our elections were free and fair and accessible to everybody, especially focusing on ADA compliance and language compliance. And then we took the curriculum and taught all the hundreds and hundreds of people who were working at the polls for the June 2010 election. Later in 2010, I was hired at the public defender's office as a legal assistant. And I was in that role for 2 years, but I really wanted to be in an attorney role. So in 2012, I took a 4-month leave of absence from my paid job so I could do an unpaid job in my office through our volunteer attorney program. And in that role, I had my own caseload. I did 7 misdemeanor trials to show them that, I'm capable of doing this. And in 2013, I was hired in my office as a misdemeanor attorney. For 10 years, I was in our trial rotation, doing the work that I think people traditionally think of when they think of, criminal defense attorneys. I was in court every single day. I've done over 50 jury trials. And I've also settled hundreds and hundreds, if not thousands of cases. So I have a lot of courtroom experience, and I have experience building relationships with people who are not always on the same side of issues as I am. I have really great relationships with a lot of our prosecutors. And I think I have a reputation for being reasonable and respectful and courteous. And that's how I'm able to settle so many cases, is that I'm able to look for common ground with people and figure out where are our mutual interests and what's going to be in the best interest and help my clients get a fair disposition. In 2013, after 10 years in trials, I asked my office to assign me to collaborative courts. I was ready to do something a little different. And in collaborative courts, it is a non-adversarial setting. So everybody's working together. And it's the prosecution and the defense and the court, and we work with treatment teams. And you look at the cases and you look at the clients and try to figure out what is going on with this person that brought them into the criminal justice system in the first place. And what do we need to do to make sure that they exit the criminal justice system and have the resources they need to lead a productive life and be a cohesive member of our community. I loved doing that work. I was really happy in that role. And that is the assignment that got me thinking about being a judge, because having done that, I did not know that I wanted to go back to the more adversarial version of advocacy. I really enjoyed being able to consider lots of interests, not just what is best for each individual client in each individual case. And also figuring out, helping the clients figure out what in their lives needs to be improved besides just getting out of jail or resolving their cases. After I was in specialty courts for a year, I went on maternity leave. And when I returned, I went to our research unit, which is where I am now. And in that role, attorneys in my office submit requests to us. Usually it has to do with a judge has ruled against them and they want to know whether we should take what's called a writ, which is an appeal before trial. And so I review the transcripts of the proceedings and I look into the case law and I tell the attorney either, sorry, the judge was right, this is not your angle, you've got to figure out something else. Or I tell them, yes, I agree with you. The judge made an error here, so let's take it to the Court of Appeal. And then I write the writ and submit it. And so in that role, I think it's prepared me well for being a judge because I've gotten very comfortable telling my own colleagues that they're wrong and that I disagree with them and that the law is not on their side when they want it to be. because I do recognize that is something I will have to do every day if I am elected and put in criminal courts. Um, I'm running for judge because I think I have the right combination of experience in San Francisco courts. I have the right knowledge of the law. Granted, I could very well be put in a civil assignment, and I do not have very much experience with civil law, but I love to learn, I love to study, and I would love to expand the base of law that I know a lot about. So I would be eager for that assignment. And I also think I have the right temperament. I'm always, as I said, I value courtesy in the courtroom. I value respect and courtesy in my relationships with the other parties, be it prosecutors or court staff, judges, witnesses. And judges obviously need to have courtesy and respect for everyone as well. And by being a public defender, I think it's prepared me well to be able to um, really listen to everyone who comes before me and let them know that I understand their position and I respect their position, especially when I'm ruling against them. Because at the end of the day, in every single case, the judge has to rule against somebody, and people think it's unfair. And what makes me happy and what impresses me with our judges is when I have a client, I've had clients sentenced to prison, but they think the judge gave them a fair shake, and they're happy at the end of the case that, they think the judge did everything right and they got it right. And that's what I want to do. I want people to feel, even when they don't get what they want, that they did have a true day in court and that they were heard and respected, and that a ruling against them isn't an indictment on their character or any judgment about them as a person. And I do think that my job has prepared me well to have that demeanor and ability to make those kind of connections with people. Because I really believe that America has the greatest justice system in the world. And I think it's important that everybody believes that our court system has integrity, whether it's the public observing proceedings or reading about them in the paper, or the people who are appearing in court, either as jurors or witnesses or litigants. And I would be very honored to be able to be on the court and uphold this spirit of integrity.
Thank you so much, Alexandra. That was a great overview, and you answered some questions I already had about why you want to be a judge and how you have prepared yourself. Griff, did you want to go through a couple questions?
Excuse me. Yeah, we'll go through the three questions. Just so everyone knows, these questions were also asked to Alexandra's competitor or the other candidate, Phoebe Buffet, just so you all know, same questions. And before I start, we encourage those that are attending tonight to drop their questions in the chat so that we can get to them directly after this short moderated session. Alexandra, first question it stems around public safety and community trust. How do you see your role as a partner in public safety for San Francisco residents? And it's a little bit of a two-part question. What is one thing voters may not know about your experience or approach that should give them confidence in your ability to keep communities safe from the bench?
Sure. So judges, in terms of what judges can do to impact public safety, we are, of course, confined to the law as it comes down from the legislature. So there are a lot of rules and laws and guidance, for instance, about whether or not somebody can be detained in custody pre-trial. A lot of that decision making is done by the legislature, and I have to follow those rules. But judges do have discretion, of course, in terms of evaluating whether or not someone poses a risk of great bodily injury to other people if they were to be released pre-trial. That's something judges have to evaluate. And in that setting, judges also have to presume that the charges against a defendant are true. So it's not, we think of the presumption of innocence, but there are certain times when you're a judge where the judge is not applying the presumption of innocence, they're applying the presumption that the charges are true, which is really important because you don't want to get it wrong. I think every judge's worst nightmare is releasing a defendant who goes out and hurts somebody when they've already been charged with a violent crime. And so I think about that a lot, and I would never want to do that. And I think one thing, I'm a public defender, and I'm sure people might have preconceptions about my willingness to kind of be lenient with people, especially around issues of release or sentencing. But I don't, I live here. I have a 2-year-old. I want to be safe in the community as well. And so I think about everybody else kind of in my same position. And I would apply the law seriously. And I would go through the factors that case law and statutes have laid out in terms of if I think there's any risk that this person might cause harm, you have to be very sure that you're imposing conditions that will prevent them from causing harm. And so I would take that seriously, and I would look at, what are the conditions? Have they complied with conditions before? Because if someone has a history of not complying with court orders, then a simple court order like a restraining order or a protective order may not be sufficient. So I would definitely want to use whatever tools I could to keep the public safe in releasing people or doing sentencing. But I certainly do not have any sort of agenda about, more people need to be released or more people need more lenient sentences. I don't think that at all. But again, I can only do what the legislature says, and I would be beholden to whatever the rules are in the scenario.
Appreciate the contextual answer there. Next question is on the topic of mental health diversion and accountability. This topic has been floated quite a bit in recent months in San Francisco regarding the courts. Recent data shows a significant proportion of drug court cases also involve mental health components. How do you view the role of mental health diversion in the justice system, and how would you balance rehabilitation opportunities with accountability while ensuring public safety when making these judicial decisions?
Yes, so I really appreciate that question because I have quite a bit of experience with mental health diversion cases because when I was the staff attorney in drug court, there are 2 ways cases can come to drug court. There's what's called an MOU, a memorandum of understanding that sets some guidelines. So some people are presumptively eligible for drug court. Like if you're charged with a nonviolent theft or vandalism, you can usually, and you have a diagnosed substance use disorder, you can come into drug court. On other charges, you can only come in through mental health diversion after the court has considered a petition and they have to apply a number of criteria. First, do you have a diagnosed mental health disorder? And substance use disorder is a qualifying disorder. I do think it gets tricky when people are what's called dual diagnosed and you have a substance use disorder, but you also have a different mental health disorder like schizophrenia or bipolar disorder, because obviously 2 very different types of treatment are needed for each of those conditions. And unfortunately, in our city, we don't have, I think, adequate programming for dual diagnosis patients. And so when I was in drug court, we did have a handful of dual diagnosis participants. Those people usually had to wait in custody a very long time to go to their program because there are so few. But, if I were a judge and it was up to me to determine whether someone should get diversion or not, if someone were truly dual diagnosis, I would make sure that I am putting them in the right program and not downplaying either their substance use disorder or their other mental health disorder to kind of try to get them into a program faster, because it only works if it's the right fit. And we really need to make sure that the programs are truly going to address the underlying issue. Um, Another component of mental health diversion is there has to be a nexus between your diagnosis and the allegations against you. And again, that's something I would take very seriously because I don't think diversion is the appropriate place for people. Like you may have a substance use disorder and you committed a crime, but if they're not connected, then you should not be in mental health diversion because all we'd be really doing is, making people more stable, but not addressing the issues that led them to create crime. And I think that would be a real problem. And again, as a judge, the last thing I would ever want to do is put people in a position where they're going to cause harm in the community. So I would also take that finding very seriously. Um, you also have to be confident of the judge, and this is where discretion comes into it. You have to be confident that the person's actually going to participate in their program, and that if they participate in the program, you can be reasonably confident that they'll keep the community safe. And so there, I think a big factor is looking at whether this person has tried treatment before. And if they didn't, and sometimes people do treatment and they're doing great for 5, 10 years, and then something happens, they experience a tragedy and they fall off the wagon. And in those cases, I think often it's appropriate for someone to try treatment again. But there are also cases where people have been unsuccessful in treatment a number of times. And I don't think diversion is appropriate for people who don't evince an earnest willingness to engage with it, because you don't want the public to think that people get endless chances in diversion. I don't want to denigrate public trust in it. And you don't want participants to think that they can come to diversion and just get endless chances. So just like I believe in the integrity of the system, I believe in the integrity of diversion. And I would definitely prioritize, people whose first time it is or have otherwise truly shown that they're ready to receive treatment and ready to comply.
Appreciate that. Maybe veering off track real quick. Can you elaborate a little bit on confidence? Like maybe illustrate what would give you confidence in.
Yeah, and I think that is hard. And again, that comes down to discretion. And I've read a number of cases about it. And, I think, again, you have to look at, I think it depends on a number of factors, maybe the severity of someone's diagnosis. Were they medicated and diagnosed at the time? I think it's different. If you were not diagnosed and not medicated, and this, happened because no one realized you were experiencing those issues. And then especially most people come in from custody, which can be helpful because we have that controlled setting. So if someone does something kind of crazy on the street, they come in, jail health diagnoses them, gets them on a medication regimen, and then they stabilize when they're in custody, and they have a very kind of drastic change in their personality and behavior from when they start in custody to the time when they're being considered for diversion. I think that's a positive indicator that I can be confident that as long as they stay on their medication and continue receiving treatment, then they'll be able to keep it together while they're out. Meanwhile, some people have been diagnosed before and they are on medication, or they're just off their medication, and you don't have any reason to believe that it's going to be different this time. I think that's something very serious to consider as well. And again, this is hard because I cannot say how I would rule in any case. The facts are always going to come into play, but these are the factors that would be really important to me. Is kind of at what stage are we intervening, and do we have a pattern in practice that would tell us one way or the other what's happened before?
Griff?
The audience Q&A is around differentiation. What distinguishes you from other candidates in the race? And beyond the obvious, what is a well-known strength or perspective you bring that voters should consider?
So I hate this question just because I've never had a case against Miss Maffei. I We were on our union executive board together for a few years, so I only know her from working with her on the same side of issues. And because I've never had a case with her, I don't know that much just about her practice. So I can really only speak to my own strengths. But um, I think my strengths and what I would bring from my experience are kind of twofold. And one is, I think, and it's hard because you obviously don't know the DAs I work with, but I do have really great relationships with DAs. And I actually applied to be considered for a judicial appointment last year. And when I told a bunch of DAs about it, they were all happy and they were supportive and they said they hoped I would get it. And I think that speaks to my ability to be fair and see both sides of the issues and kind of recognize what the true goals of the criminal justice system are. And of course, as a defense attorney, I have to represent one interest of it, but I think the confidence of my opponents and my ability to have a neutral role speaks to my ability to see the other side and be empathic toward the other side. And I think that is not a strength that everyone has, but it is a strength that I have. And I think my background plays into that, right? I grew up in a law enforcement family. I always viewed criminal justice from a prosecutorial lens. So I do have very deep-seated experiences with both sides. And I think that makes me uniquely positioned to be open-minded to both sides, and not just on criminal issues, but civil issues too, to understand there are many perspectives. And at the end of the day, it's my job to determine exactly what the facts are and how the law applies to them and what the just outcome is under the law. And then, as I said in my opening statement, um, in dealing with clients, my clients particularly, I usually meet my clients at very low points in their lives. I deal with a lot of people who are struggling with mental illness or substance use. Um, I've had to learn to be very patient and to understand that people might lash out at me, and it's not about me at all. It's about something that's going on with them. And it can't it can't impact the way I think about this person or their case or what needs to happen. Instead, I need to help them figure out how to tell me what they need, or what they're looking for, so I can do my best to help them achieve their goals. And as a judge, again, not just in criminal, I've spoken to another judge who said in family law, tensions get really high and people are angry and they're angry at each other and they're angry at the judge. And the judge needs to remain calm and even keeled and bring the temperature down. And I do think I am uniquely positioned to be in that kind of taking the temperature down, being patient, and being able to communicate with people no matter what kind of crisis they're in.
Very thoughtful answer there. Thanks so much, Alexandra. I think we can now move on to audience Q&A, excuse me. I don't think I saw any come through the chat, but given I think we have some time, and there's, I think, room for people to actually come off mute. Why don't we just, whoever does come off mute and ask a question, just be mindful, don't be too lengthy, but in case everyone has a question. But why don't people start raising their hand and I can pick on them to come off mute and ask you live whatever question they may have.
I guess your thoroughness has really overwhelmed her.
Well, there's only so much we can talk about it. So I know it's really hard to have questions because we can't talk about very much.
Exactly. No, but you've given just a wonderful overview from your perspective because, it's not often you get to hear, the intricacies from a public defender's, that side of things. And, there are some preconceived notions sometimes, and it's good to hear from somebody who's been there in those trenches, the views that you have and how you approach things, because I know it's not as cut and dry as many people may think.
Yes. And I know other public defenders have run in the past on kind of a criminal justice reform oriented platform. And I just don't think that's the place of the judiciary. I think it's the place of the legislature if there are reforms to be made. And so, people are obviously entitled to run for whatever reason they want, but I do think that's sometimes shades the perception of me. And I really appreciate this opportunity to kind of talk about who I am and not who other people are.
Well, you're very welcome to give a final remark, and then I can close this up since we, got so much done in such a short period
Yeah.
of time.
Thank you. Well, I just want to thank everyone again for listening to me and hearing me out. I am sincere that I love our city and I love our system. I think we have a lot of very smart, great judges in San Francisco, and I would be honored to be part of that legacy. And, as someone who lives here and as someone who has a small child here, I think my concerns are probably very similar to a lot of your concerns, and my perspective on our city's strengths and weaknesses are probably similar too. And, you don't leave your life experiences at the door as a judge. You do apply the law, but you also have to think about how your decisions are going to play out. Like I said, you never want to do anything that could hurt the community you love. And so I would be very honored to be elected and to serve. And even if I'm not, I'm proud to have a job where I do serve our community because it's very important to me.
Well, we can't thank you enough, Alexandra, for joining us tonight. And, thank you, Griff, for moderating and guiding us through the discussion. And I'd like to thank everybody who joined us this evening to listen to Alexandra, share her views and to give us a little more insight on this important race that's coming up. And so thank you very much, Alexandra, and thank you all. And I hope everybody has a wonderful evening.
Thank you for hosting me, and thank you everyone for your time and for listening.
Thank you.